would like to call this meeting to order. Thank you for joining us during our weekly virtual MLS breakfast meetings. My name is Sharon Wang with Remax Realty from Temple City. A few housekeeping tips. All participants will be muted upon entry. And should you have a question or a comment, please enter it into the chat box, and the host will read it during the Q&A portion of the meeting. Please remember to join us weekly, as we will have virtual breakfast meetings every Thursday at 9 a.m. Please see the different ways to join us on the screen. As always, this meeting is being recorded and will be available online on our YouTube channel, West and Gabriel Valley Realtors. A little about me. My name is Sharon Wang, and I am your April MLS Monthly Program Chair. Please remember to follow WSGVR social media on Facebook, Twitter, and Instagram. You can also watch all of our pre-recorded videos on YouTube. WSGVR now offers text messages, updates. Text the word WSGVAR to the number 313131. Today's guest presentation will be provided by Paul Cheng, attorney, and David Ching, attorney, covering the topic of new laws regarding COVID-19 and its impact on current business and real estate community, followed by our president's message given by President Mindy Ye. Paul Chen is the managing partner of a team of distinguished attorneys in Pasadena, California. Mr. Chen has extensive legal experience in small to large business operations and commercial realty transactions. He has counseled individuals and businesses at all levels in a variety of transactional and litigation matters, including contract, landlord-tenant, land use, employment, franchise law, fraud, identity theft, immigration, civil rights violations, products liability, trademark violation, construction defects, and general torts. And also David Ching. David Ching earned a bachelor's degree of Arts in Business Economics from University of California, Irvine, and graduated from University of San Francisco School of Law. He has worked as a lien hearing representative in workers' compensation and settled millions of dollars of claims. David has also checked in firms specializing in civil rights, family law, complex torts, landlord or tenant, and personal injury. He is empathetic with clients and strives to make a personal connection with them to better understand their legal disputes. He now works primarily on business and employment litigation, contract disputes, and real estate disputes. Now, I'm gonna hand it over to Paul. Paul, are you ready?
Yeah, I'm ready. All right. What I'm going to do is I'm going to share my screen. I'm just looking right now. Let's just see. Morning. My name is Paul Chang. I'm here with David Ching, and basically I wanted to welcome all of you. Really thank you guys for taking the opportunity to learn more about COVID-19 and the laws that apply to your business, both in business as well as in real estate. Really excited for you because there have been very few lectures on this area of law. I do want to say that the reason why there have been few lectures on this area of law is because laws typically take a minimum of 6 months to a year to debate and write. But this has been written really over a number of days. And so what you're going to find is, as we're presenting today, we're going to do our best to give you the information. I do want you to know that the laws are evolving quite a bit. And what that means is that every few days, a new interpretation from the government will come out trying to supplement or explain some of the laws that have occurred. just over the last few weeks. So let's begin. And David, are you unmuted as well?
Yes, I'm here.
Okay, very cool, very cool. So there's several sources of legal authority, and I'm just looking at my screen on the left side, so not trying to ignore you guys here, but there are several sources of legal authority that I think are very important for people to know. And the first one is HR 6074. The next one is HR 6201. And the third one is HR 748. So just to let you know, HR 6074, although it is very important, has a lot of COVID testing information, but it's not very important for purposes of employer-employee. The next one, HR 6201, it does have a lot of information in relation to employer-employee and for businesses. And HR 748 really deals with businesses. A lot of you have been hearing about PPP, CARES Act, things of that nature. That's going to be in HR 748.
Just to add on a little bit, HR 6074, in addition to what Paul was just saying, it's mostly about appropriations to the FDA, the Small Business Association, Department of Health and Human Services. So that's really what that bill is all about.
The next one that's very important is the executive orders have been signed. This is just one of many. And so there's N3320, but there are many, many orders that have been signed by Governor Newsom, as well as county orders. For example, Los Angeles has its own county order. San Francisco has its own county order. Orange County has its own county order. So these are all very important. Another one that you have to be careful of are city orders. For example, the city of Arcadia has a city order. Many of you do business in the city of Arcadia. It has its own city order as well. Now, understand one thing. What does it mean by the more protective order supersedes the less protective order? It means that if you find that one has more protections over another, it doesn't mean that if you use federal law, for example, but the state law is more protective, that you're in compliance with, quote unquote, the law. So what you have to do is understand that if you find that there are two statutes that seem to contradict, but one has more protections than another, then if you go with the other law that has less protections, you are compliant with the law. So for example, there was a long period of time, and there are still many statutes like that, where you could not, the federal law did not address discrimination as it related to transgender rights. Well, California did. So does that mean that if you complied with the federal law where it did not involve transgender rights, that you were compliant with all law? And the answer is obviously not, right? You would need to make sure that you need to comply with California law. So for example, LA City will require you on Friday to start wearing masks if you're out in public. Does that necessarily mean that if the federal law doesn't address it, that you're in compliant with all law? And the answer is no, right? I mean, you would need to make sure that you would need to wear a mask on Friday. So hopefully that kind of explains a little bit to you when you see different bodies of law, how to be able to look at it, is that the more protective law typically would end up controlling. Obviously, there's the issue of legislative intent. There's an issue, did the legislature actually care about this issue? But again, just to kind of explain the different orders that are in place.
Good morning, Paul.
Yep.
We're getting some requests if you can enlarge your screen. We're seeing a screen with three different PowerPoints on them.
3 different PowerPoints. Okay, hold on real quick.
With the same PowerPoint, but the 3 different slides.
Same PowerPoint, but 3 different slides.
I think you're sharing the screen.
The other monitor.
Yes, the other monitor.
Okay, hold on real quick. You want me to share the other monitor?
Because we're seeing a monitor with next slide, notes, and
yeah, I see that too. Okay, sorry about that, everybody. Display settings, swap, presenter view, and slideshow. Is that better?
Yeah, that's it.
All right, cool. All right. Okay, cool. So has COVID impacted everyday life and businesses? The answer is absolutely. Businesses are required in many ways to provide leave to their employees. And so what they've decided to do is close. The second statute that we're talking about that we'll go over in terms of the Emergency Paid Sick Leave Act, as well as the expansion of the FMLA, essentially has required many employers, they have decided that they need to close because the Department of Labor has said that if a company closes before or even after the law is in place, HR 6201, that it does not have to comply with the law. I mean, it's as simple as that, because the law only applies to the employer-employee relationships. Another example in the real estate industry is that many evictions are stayed. What Governor Newsom has done is it's given authority and power to counties and cities to be able to stay evictions. It doesn't mean that the rent is waived, but it essentially means that the evictions are stayed. Well, for example, in the city of Arcadia has a moratorium out that essentially says you can no longer evict, for a certain number of period of days. You see that in other cities as well. And so another issue is that the courts, in many ways, are no longer open for most hearings. For example, in Los Angeles, criminal courts are open for hearing. However, many of the criminal courts are, you just call in. I mean, you're no longer physically going in. The civil cases are just getting moved on, meaning that they'll continue it for 60 or 90 days. Many people are staying at home, just really out of fear. They just don't have work anymore, and less people are spending money. So overall, the answer is yes, it has impacted everyday life and business. How is COVID-19, how does it really apply? So when I talk about COVID-19, I'm really talking about the laws for COVID-19 that we're going to be speaking on today. On the federal level, there were 3 major pieces of legislation that currently apply to business, and these have a lot of impact. The first one is going to be the Emergency Paid Sick Leave Act. That's a pretty big issue that we're going to really expand on today. Another one is the expansion of FMLA. It doesn't get rid of the FMLA, but it expands the FMLA. Another one is the CARES Act that we're going to be speaking on. And another one are business loans. I would recommend that if you're, and I've always said this, if you're a real estate agent, that you try to do a value add, meaning that you try your best to be able to take your clients in many different routes that other people aren't doing during a market downturn, so you could be able to have a value add for your client. The federal legislation that we're looking at again is HR 6074, the Corona Preparedness and Response Supplemental Appropriations Act. Again, as David has said, the first one is more based on appropriations. The second one is the HR 6201, Families First Coronavirus Response Act, that occurred on March 18th. And the last one is the HR 748, which is the Corona Aid, Relief, and Economic Security Act. In terms of the first one here, this, although we've listed it, isn't as applicable. This one here is split into 2 parts that are very relevant to most people. One is the Emergency Sick Leave Act, and the next one is the expansion of the FMLA. And then the third one here, the third area of law, which David is going to expand on, is the CARES Act, the PPP, et cetera. Okay. So let's take a look at emergency paid sick leave. It's effective April 1st, 2020. I've actually said it's effective April 2nd. I understand it's past April 2nd, but there's been kind of a debate between attorneys. But it's April 1st to December 31st, 2020. And basically what it says is that it applies to employers with fewer than 500 employees. Now, I do want you to know that there is a carve out for under 50 employees, but it's a little bit ambiguous. But the specific statute says it applies to employers that are under 500 employees. The question becomes, well, what happens if there are over 500 employees? And the answer is this doesn't apply. However, about 70 to 80% of businesses, and depending on the industry, almost 99% of businesses this applies to. So the employee is entitled to 2 weeks, which is 10 work days, of paid sick leave at the employee's regular rate of pay, not to exceed $511 per day, or a total of $5,110 if the employee is unable to work or telework because the employee is quarantined due to a federal, state, local, or doctor's order, or the employee is experiencing COVID-19 symptoms and is seeking medical diagnosis. Now, what does that mean? Basically, you have to think about it if the employee has COVID-19 or is suspected to have COVID-19, this would apply. Now, I also want to say this. The law requires you to not be able to work or telework. And from an employer's perspective, and I believe for all perspective, that is one of the triggering requirements, is that an employee must be able to show that they cannot work or telework. If they are unable to show that they cannot work or telework, then they aren't able to get the emergency paid sick leave act. Now, I also want to say this. We believe, attorneys that practice in this area of law, that there's going to be a whole host of new lawsuits as soon as COVID, the pandemic, goes away. I believe personally, just being Chinese American and having family overseas, that just like SARS and MERS, that as soon as it begins to heat up, which is fairly soon, I would say by June 1st, COVID-19, I've been saying this very, very early on. People have said that I'm just being optimistic. I believe that COVID-19, once it heats up, it's not going to be around. It's going to be significantly diminished. And when that ends up happening, you're going to find that a lot of employees are going to question the actions of their employer, whether it was legal or illegal. And so because of that, from a business perspective, we have to be very careful in the sense that you have the legal, illegal, and then you have the business, kind of the business ramifications, the business decision that you have to make. Does that make any sense? Is there a way for anybody to speak? Oh, David can speak up. Does that make any sense what I just said, David?
Yeah, it does.
Okay.
Really, it's just we need to be clear that the employee is unable to work or telework.
Okay. Yeah, it's just, you have the legal requirements, and then you kind of have the perception, because a lot of times, litigation, I find, is all based on perception, which is unfortunate, right? Because a lot of the truth, unfortunately, isn't there. It's very hard because it's in the parameters of litigation. Both civil and criminal cases are like that. So it's all based on perception. So, but what you do have to understand is that the employee must be unable to work or telework because the employee has COVID-19 or is suspected to have COVID-19. They're able to get 10 work days of paid sick leave at their regular rate of pay. So the regular rate of pay, for example, for an 8-hour day, let's say, let me just see real quick. I don't mean to do this, but I just saw, okay. Ling, who is the most amazing person, she just sent me a text. So I will try to avoid that. In terms of the regular rate of pay, let's say that they make $200 a day, you would pay them $200 a day, all right? Because it must not exceed $511. It doesn't mean, because a lot of employees are going to say, well, my average rate of pay is $200 a day. That's approximately how much I make in an 8-hour day. Therefore, you must pay me $511. That is incorrect. That is incorrect. It's not to exceed $511 per day, up to $5,110 total if you have COVID-19 or you're suspected to have COVID-19. All right. You get 2 weeks up to 80 hours at 2/3 the employee's regular rate of pay. All right, so it's 2/3, $200 a day. All right, and David, on this one, I'm just trying to look. There's also a cap on this too, I believe, right?
Yes, it's $2,000.
$2,000. Okay, so sorry about that. Not to exceed $200 a day, up to $2,000, because of a true need to care for an individual who is quarantined, to care for a child under 18, or a substantially similar condition as specified by the Secretary of Health and Human Services. Just to let you guys know, David and I, particularly David, spent hours and hours of hours combing through this statute. It is one of the most, unfortunately, difficult statutes to read because it was written so quickly. So really appreciate everybody that worked on, particularly David. Think of it as the employee is caring for a child or is caring for someone with COVID-19 or is suspected to have COVID-19. You are able to get 2 weeks, 80 hours at 2/3, up to $200 a day, a maximum of $2,000. Okay? So here are some questions that we have been getting from a lot of our clients, both employers and employees. We've been answering them, so we can address a lot of these questions now. This is only for the Emergency Paid Sick Leave Act, not for the expansion of FMLA. However, many of it overlaps. Okay, so what if my employees normally work an alternative work week, meaning 4 days, 10 hours a day? For full-time employees, they get 80 hours of paid sick leave. The statute specifies 80 hours. Thus, it is not required to give them more than 80 hours in total. All right, so it's a maximum of 80 hours in total. How many hours of emergency paid sick leave do part-time employees get? This is a great question because an employer will say, well, you know, it's a maximum of a certain amount, right? 80 hours in total, but my employee doesn't work 80 hours in total. What do I do, right? The statute provides the employer must give the part-time employee equivalent to 2 weeks of paid time off, equal to the average number of hours the part-time employee normally works. All right, so what does that mean? Let's say that over 1 week, an employee works approximately 30 hours. So 2 weeks of that is going to be 60 hours. It's not going to be 80 hours. So that's the amount that you're going to be giving. So I don't want you to feel that because there's a cap, you have to maximize the cap. The cap is really over a 2-week period, which is a 10-day work day. That is the cap. Okay, I actually see Judy Chow sending a message. I know it's very distracting, I apologize. So can I ask the employee who wants to take this federal emergency paid sick leave for a doctor's note? You have to remember, emergency sick leave is going to be different from the expansion of FMLA. So in your mind's eye, you have to understand that people come to you with one specific issue. They say, I want to take leave. But in your mind's eye, you have to split it up, HR 6201, as attorneys do or practitioners do, into 2 separate issues, right? The first one is going to be sick leave, emergency sick leave. And the second one is going to be the expansion of FMLA. The emergency sick leave is going to be split into 2, right? And then this is obviously the first subsection. So can I ask the person who wants to take the federal emergency paid sick leave for a doctor's note? The short answer is yes, right? The short answer is yes. The long answer requires an understanding and distinction of several California employment laws. In California, employees are entitled to their normal 24 hours of paid sick leave. Employers are generally not permitted to ask for a doctor's note for an employee to use this leave. For these sick days, employers cannot request a sick doctor's note. Normally, employers may ask for a doctor's note after the 3 days of California paid sick leave. Excuse me. I just coughed. I think the meeting should be over. Okay. So what does that mean? California has its own sick leave. California has its own sick leave. So the minimum requirement is that you have to give 3 working days off, and they're paid to your employees when they call in sick. And typically, as a general rule, you're not going to need documentation for those sick leave because the employee gets it no matter what. However, under the Federal Emergency Paid Sick Leave Act, it is different from the California Paid Sick Leave Act. And so therefore, the federal allows you to get it. However, if an employee is getting under the California sick leave, which is 3 days, you generally do not want to ask for documentation and proof. So again, in your mind's eye, again, and I just did it, you split your mind, right? And then under the the expansion, the Emergency Sick Leave Act, you have whether they are experiencing COVID or whether they are taking care of someone in regard to COVID. If they're experiencing COVID, it's going to be the 100%, right, David?
That's correct.
If they're experiencing COVID or think they're experiencing COVID, it's 100%. If they're taking care of somebody that has COVID or thinks they have COVID, it's going to be the 2/3. And now within the sick leave in general, it's split again into California sick leave, which does not require you to be able to get, the employer is not going to be asking for a sick leave doctor's note, but the federal one, you are able to. And then the other factor that your mind has to split is between, yes, you can be able to ask for the doctor's note, but are you going to be asking for the doctor's note with the understanding that the employee may trigger an employee to go to an attorney, and then the attorney is going to be poking all of these holes and thinking about all the statutes that could be violated when you did not ask for a doctor's note. But again, that's a business decision. But I just want to put it out there because a lot of employers have been basically saying, well, geez, Paul, after you talk about all this and all of the factors and you're trying to simplify it into putting it into different buckets, I'm just going to close, right? If I close, I don't have to deal with this anymore. So these are things that we have to think about. Can I ask the employee who wants to take this federal emergency paid sick leave for a doctor's note continued, pursuant to FEHA, ADA, etc., it is unlawful to discriminate, retaliate, or harass an employee for taking sick leave. This means if an employer enacts a policy to use this emergency sick leave, it must be applied uniformly. So there's a couple things. I'm going to unpack this a little bit. What does that mean? Basically, if an employee comes to you and they want to use any type of leave whatsoever, and you basically discriminate against them, retaliate against them, or harass them, whether or not you feel that employee is right or wrong, if you do that, that's going to be considered illegal. So let's say someone comes to you, this is just an example, and I've had this a lot, where an employee goes to their employer and they say, oh my God, I'm working on Christmas Day and Thanksgiving. I know the laws, I get overtime on Christmas and Thanksgiving. The answer is you don't get overtime on those days. A lot of people don't realize that. If you have a national holiday and you work, you don't get overtime. And the employer says, oh, wow, is that really how you feel? And the employee says, yeah, that's really how I feel. And the employer says, why don't you ask the person in the unemployment line, right? They fire them. The employee could be absolutely wrong. Now I'm going to take this example and make it into COVID. There are a lot of employees that will come and they say, hey, you as the employer need to give me masks. You as the employer must provide gloves. Well, there isn't a statute for that right now, right? Now, obviously on Friday, if you're in LA City, the employer is required to have masks. But as of right now, no. Let's say someone came up to me and they said that. They said, Paul, I'm so scared to work here. I need to have gloves. And I say, yeah, well, you know who has a lot of gloves? The person that's in the unemployment line. Why don't you go ask that person? Well, if I were to say that, that would be retaliation, wrongful termination, even if the employee is wrong. Well, David, we're going to have to really rush through this. I didn't mean to talk for so long. Okay. Am I talking too slow? Maybe I'm talking too slow. Okay. Can I ask the employee who wants to take this federal emergency paid sick leave act for a doctor's note? HR 6201 does not specify that the employer cannot request a doctor's note. It is important to distinguish California Paid Sick Leave Act. We've already explained that. This means if an employer is using their California 3 paid sick, their 3 days off, then you can't, we would not recommend you asking for a doctor's note. However, if they're using the federal emergency paid sick leave act, then the employer may ask for a doctor's note. However, it would be prudent to get it in writing, which leaves the employer, okay. So let's rush through this. Can I ask the employee who wants to take this federal emergency paid sick leave for a doctor's note? You cannot require to exhaust other types of leave before using the federal emergency paid sick leave act. What that means is that the employee does not have to use their sick leave to be able to, or pay time off to be able to get this benefit. It's a benefit, it's benefit, it's benefit, okay? Okay, the PowerPoint's been sent over to you guys. It'll be available to the team as well as to everybody. You guys know every time I lecture, I tell you guys that I want you to be able to use our slides, you know, just be very comfortable about it. Don't worry about it. Can I ask the employee, okay, this is very important. Typically an employer requirement is that if the employer makes a business decision and it's not based upon discriminatory animus, then it is legal, not illegal. However, under the Emergency Paid Leave Act, is that an employer must not condition an employee's leave based on the fact that the employee needs to have a replacement. So let's say that an employee comes to you and they say, hey, I'm feeling really sick, or I have to take care of someone with COVID. And the employer says, you know what, I can't have you leave because we're just really too busy. You're a critical component of my business. Under other areas of law before COVID, that is totally okay because it's a business necessity. It's a business decision. But under the emergency paid leave, it is not okay for an employer to condition. So we've already talked about this, but this is a great summary. If an employee is subject, which means that they're experiencing COVID or seeking a medical diagnosis, 100%, they get 100%. If an employee is caring for an individual, they get 2/3. So it's 100% and 2/3. And we've talked about this already, okay? So what is this issue of the tax credit? The tax credit issue we've seen quite a bit. So the federal government will pay as a tax credit or issue as a tax rebate 100% of the qualified emergency leave subject to the limitations that we see here. Now here's the problem. One, I'm not a CPA. I'm very sure the board is going to bring in somebody to be able to explain this. I do want to say that when I read it, you basically get an offset for tax credit, and it actually says within the statute that they'll give you essentially a rebate. They'll actually pay you back for monies that are given out. I do want to say that many companies aren't buying this. They're thinking that it's basically like Social Security. You know, it used to be, let's say, 62. Now it's 66 or 67. In a few years, it's going to be 70. But what is the government going to be doing when it's giving under the CARES Act, I believe $238 billion out as a loan forgiveness, and they're basically rebating all this money to companies? They don't think that the U.S. government is going to be able to rebate anybody. Plus, essentially companies have to float this amount of money until essentially the next cycle during tax time. Many companies can't be able to do that. So they're deciding either to terminate, furlough, or close. The statute says that employers with fewer than 50 employees, and this year is a little bit ambiguous, may file for an exemption if the impositions of such requirements would jeopardize the viability of the business's going concern. Now, I do want you to know that the statute basically, both in the emergency paid leave as well as the expansion of the FMLA, say fewer than 500 employees. It does have a carve out for 50 employees. It says that the Department of Labor is going to be essentially explaining what the exemption is. But I do want to say here that this may file is a little bit, we've made the decision that there may be an exemption for you to file. However, many attorneys have taken the position that essentially under the emergency paid leave, as well as the expansion of the FMLA, that you're not going to, if you're under 50 employees, it doesn't apply, okay? HR 6201 states the Department of Labor may exempt a small business with fewer than 50 employees, and basically says if the imposition of such requirements would jeopardize the viability of the business as a going concern. So if you're going to fall within the under 50 exemption, you need to be able to show that it's going to jeopardize the viability, not merely hitting your bottom line. It has to show that, look, if I were to give this benefit to my employees, then it's really just going to hurt all the employees. The Department of Labor has not implemented procedures, unfortunately, and it has not defined what the requirements are for jeopardizing the viability of the business as a going concern. Now, it looks like here, David, has everybody been disconnected, or?
No, I still see 222 participants.
Oh, okay. Now it went down from 238, so that must mean that we're doing a good job. So the Department of Labor's website does state this. Small businesses with fewer than 50 employees may qualify for exemption from the requirement to provide leave due to school closings or childcare unavailability if the leave requirements would jeopardize the viability of the business as a going concern. It appears to only exempt employers from providing 2 weeks leave for childcare. It does not exempt employers from providing leave if the employee claims to experience symptoms or is quarantined or to care for an individual. Now, this was a big debate that I had with David as well as other attorneys, because the statute seems to exempt under 50. However, David's position here, which I think is relevant, I mean, something that we have to consider, is that it appears on the Department of Labor website, not the statute. Now, the Department of Labor website is not the statute, but the Department of Labor website provides guidance. It doesn't mean that just because it says it's there means it's legal or illegal. However, obviously, if it's on the Department of Labor website, we would take it very seriously.
I'm going to jump in here really quick. So just to clarify, for the HR 6201 is enacted by Congress, which empowers the Department of Labor, which is an agency, to create or promulgate rules in the Code of Federal Register, and that's what I'm talking about when we're saying formal regulations have not yet been created. So
yeah, so what the code of, okay, so there's something called CCR and there's something called CFR, and it may not seem important, but it is important for attorneys, and I've always tried my best to explain things from the hearer's standpoint, but also to let them understand how attorneys feel. So the CFR is the CCR, sorry, is the California Code of Regulations. And David, for the federal one, what's the acronym for that again?
Federal
rules.
FRC.
Federal.
Yeah. Why am I blinking out?
No, it's okay. So what are these, why did David refer to that? And why did I refer to the California Code of Regulations? Well, employees of the government, they know the statute, but they aren't all attorneys. And so, but they need to comply with a Bible, right? And so what is this Bible? For California, it's the CCR. And then for the federal, it's the Federal Code of...
Code of Federal Regulations, CFR.
CFR, Code of Federal Regulations. Now, the Department of Labor website, the reason why David talked about the CFR, the Code of Federal Regulations, is because the Department of Labor has it on its website, but if the Department of Labor was really going to comply with it, it would go into the CFR. And attorneys many times use the CFR to see what the Department of Labor feels about a statute, because the CFR will cite to a statute and then it'll explain it for their employees, many of them which are non-attorneys that work at the Department of Labor. So that's the reason why he said that. Expanded Family Medical Leave Act. So we're leaving the Emergency Paid Sick Leave Act, federal, and we're going into the Family Medical Leave Act. So FMLA. For companies that have over 50 employees, it is very critical for you to understand FMLA. Basically, it allows an employee to take 12 weeks off over a 12-month period to be able to take care of themselves if they have a essentially serious health condition or they need to take care of somebody that has a serious health condition. So everybody knows that, but it's unpaid. It's unpaid. So you're eligible if you've worked for at least 12 months and you've worked at least 1,250 hours in the past 12 months, and you worked at a location where there are at least 50 employees. Everybody understands that. If you're in HR, you totally get it, right? California has CFRA in addition to FMLA, but everybody knows it as FMLA. California, people talk about synonymously with FMLA CFRA. So what does the expansion do? Very important. An employee is now eligible for Emergency Family Medical Leave Act in addition to the current FMLA if the employee has been employed for only 30 calendar days. That's it, just 30 days. It applies to employers with fewer than 500 employees. There may be an argument for a carve-out. An employee who takes emergency FMLA leave takes the first 10 days without pay. So there's been a lot of confusion. All of the research that I've been reading on this, even online, and attorneys go online just to research just like everybody else. Basically, they don't talk about the first 10 days that you don't get pay. So this is very important. The next 50 days after the first 10 days without pay, basically you take it with pay. So the employer shall pay. So this shall be shall. 2/3 of that employee's regular rate of pay, whichever is higher, $200 a day up to $10,000 for the 50 days or 10 weeks. 50 days being working days.
50 work days, yeah.
50 work days. Thanks, David. Employee requirements. The employee may use the emergency FMLA if the employee wants to take leave to care for their child under 18 because the child's age or their regular daycare is unavailable. This is the only situation. Now, this is what I want to say again. A lot of attorneys take the position that that's not true, that there's more than this is the minimum, but there are other things that you could be able to take leave on. And I want to say that if we take a different position, we will let everybody know, but bare minimum, if this is the basis for the leave, you absolutely get it. You absolutely get it. And I do recommend for you guys to go to the Department of Labor website. I read it, I've read it again. It basically says if the employee wants to take this leave, they get it, but it doesn't say that this is the only way that you can be able to take the leave. Now, David, do you disagree with that? It's okay if you do.
Yeah, the statute says created the emergency FMLA leave for this purpose. That's what the statute says, going back to it. There may be other situations that are covered that get expanded by the DOL or just are inherently there according to regular FMLA, but according to the statutes, I think this is another point where Paul and I have a little bit of a debate going back and forth.
Yeah, it's just, again, not to belabor the issue, but I think it's very important if you're an employer and an employee that you go here to, and do you guys see it? It's the DOL.gov/agencies. Let me just expand this oh, you can't be able to expand. Hold on real quick. Let me just. To go to this website, this answers many of the questions. So this is where much of the PowerPoint, some of the PowerPoint comes from. Was this provided to everybody, David?
We can send that out separately.
Okay, so hopefully everybody can be able to see that. Again, I've always said everybody that, it's not a rocket science issue. We're just doing the research on it, so. Okay. So the employee must not be able to work from home. This is just like the Emergency Sick Leave Act, is that you must be able to show that you cannot work or telework. Because in this situation is that if someone says, hey, I want to take leave. Why? Well, the child's school is closed. Everybody can say that. Everybody can say that. However, as a triggering requirement, you must be able to show that you cannot work or telework. And in my opinion, many of the employees will abuse this. Many employers will take some pretty harsh decisions because they think it's being abused, and there's going to be a lot of litigation that occurs. So it's the reason why the employers have basically said we're just going to fire everybody, because you can basically just go get unemployment insurance. Can an employee take emergency paid sick leave and emergency FMLA together? The answer is yes. Emergency FMLA is paid for the first 10 days. Emergency paid sick leave is unpaid, but emergency paid sick leave is for 10 working days. So if you think about it, the emergency paid sick leave provides for 10 days. The expanded emergency FMLA does not provide the first 10 days. So it appears, we don't know. This is crazy. The intention was so that the employee can take 2 weeks of emergency paid sick leave, then supplement the next 10 weeks with emergency FMLA if they qualify. And I've said this a lot to the team many times. Our system, our judicial system is based upon statutes and cases. So when I was becoming a US citizen, one of the things we learned is each branch of government. And so the judicial branch was made to interpret the law, right? The legislature writes the law, the executive branch enforces the law, and judicial branch basically interprets the law. And what does that mean? Is that they're given equal weight. Well, this is unlike many countries in Europe and Asia. They're civil code countries only. So essentially, many people that read our statutes from foreign countries say, man, your statutes are written very poorly. They're written with much interpretation to be allowed. And my response to them is, yeah, because statutes are written so that courts can be able to interpret it. Obviously, nobody likes to write it in an ambiguous manner, but that's what the court system is for. So the court system, for example, in Asia, it doesn't matter what the appellate court says. It only matters whether the judge has followed the black letter of the law only. So here, it appears the intention was so that employee can take 2 weeks of emergency paid sick leave and supplement the next 10 weeks. Is there a tax credit? The answer is yes. It's 100% according to what we read in the statute. We don't know how accountants feel about it. I think the accountants are basically saying the same thing, which is, yes, it's written how it's written, but we do want you to know that there's a risk, meaning that there's a possibility that at the end, the government may extend the time, you have to float the money, or they may not pay it back. Obviously, a lot of people would sue, but I'm just letting you know that's what I believe a person is saying. It's a calculated risk. They're kind of making what an attorney would say as well. As an employer, am I exempt? If I have fewer than 50 employees, it's very similar to the Emergency Sick Leave Act. Basically, there's a carve out of 50 employees. If the imposition would jeopardize the viability, again, the Department of Labor has not implemented procedures, but we're hoping that they will. We were told that on Tuesday, they were going to have all of these procedures come out, and the answer is it didn't come out, right? And the Department of Labor is scrambling just like everybody else is, because all of these new statutes have just come out and people are trying to figure out what it means. And again, it takes really 6 months to a year for a new law to come out. For something to come out over a number of days or a number of weeks is unheard of and very scary. Here's the summary of paid sick leave and expanded FMLA. Basically, an employee can take 10 working days. You know what? Because we don't have time, you guys should already know this. If you don't, just look at the PowerPoint, okay? So employers are required to post this poster. So this is the poster. You want to make sure it's posted. It's one of the attachments. Okay, now let's talk about the CARES Act. So David, are you going to be able to speak about the CARES Act in a faster way? Okay, all right, thanks.
I'll talk quickly about it. So there are, the CARES Act has 4 parts to it. The first part is that there's a Paycheck Protection Program. The second one is the Economic Injury Disaster Loan Emergency Advance. There are also 2 lesser used Sba Debt Relief and Sba Express Bridge Loans. There's also an individual stimulus package. It's $1,200 to each American, and there are also unemployment benefits. Jumping into the PPP, Paycheck Protection Program. It's effective on March 1st to December 31st of 2020. The purpose of this program was to keep all employees on payroll. The SBA will actually forgive the loans if all employees are kept on the payroll for 8 weeks and the money is used only for payroll, which includes health benefits, sick leave, FMLA, rent, mortgage, interest, and quote unquote any other debt obligations that were incurred before the covered period or utilities. So
we confirm this. The definition of expenses are for payroll, rent, mortgage, interest, and any other debt obligations incurred before the cover period or utilities. There are some people, some attorneys have considered it is just for payroll only, but that is not what the statute says.
Mm-hmm.
Okay.
The SBA has instituted or created interim final rules on April 2nd, meaning it is currently in effect, but it's still subject to the 30-day notice and comment period and further changes. This notice and comment period is the method in which a administrative agency, for example, the SBA, which stands for the Small Business Administration, to create rules. There's a limited amount of money that's out there for the PPP. And it's loaned on a first come first served basis. We've heard rumblings that it's starting to become more and more limited. So it may be prudent to look into that as soon as possible.
Our understanding is that I don't mean to scare everybody, but if you haven't applied for it, you probably need to apply for it as soon as this seminar is over, because we spoke to a bank yesterday just to confirm much of this information. They said the money's almost gone. So, you better do it right away.
We're also going to be sending out some of the forms along with this PowerPoint, so you can look into it and consult with a bank. Next slide. So the requirements to get one of these SBA PPP loans is you have to be a small business under 15 USC 632 sub B. It's actually a little unclear as to what the exact requirements are on it. It's a little vague, but it's actually also very broad in the same sense. The second is that the small business must have fewer than 500 employees, is based in the United States, and is a tax-exempt nonprofit organization and under IRC 501c and 3 and 19, or a tribal business. It's actually tribal, not trial. The other qualification is any business with an NAICS code that begins with 72 with less than 500 employees per location. Sole proprietors, independent contractors, and self-employed persons are also eligible for these loans. So you don't have to meet each and every single one of these requirements. It's just any one of them will suffice.
See, this is huge. So this is huge. Basically, almost everybody qualifies. Nonprofits, independent contractors, self-employed persons, sole proprietors. You guys have to file this right away, because it is first come, first serve. My understanding, it was 238 billion with a B. Money is almost gone. There's current legislation to have a second wave, but we don't know if the second wave is going to come. So as soon as this meeting is over, you can contact us, you can contact your bank, but you got to get on it. Okay, I'm sorry. I don't mean to scare everybody. Next.
Can you also zoom out?
Oh, okay. Yeah. Oh, I just wanted to make it easier for you. Sorry about that. Okay.
I can see it fine. So how you actually apply for the loan is there are two forms. The SBA form 2483, and also that's the actual loan application, and then there's a loan forgiveness form that you should fill out. You should take those to a SBA 7A lender, bring the application form, and I'm sure the bank will also ask for additional information, which we'll actually talk about in a little bit. And go find one of those banks that are actually a SBA 7A lenders. You can find those banks on the SBA website and take that information there and apply for the loan. So the question is, how much money will the loan provide? The lender will usually decide how much to loan. However, the maximum amount is actually the average total monthly payments by the applicant for payroll, mortgage payments, rent payments, and payments on other debt obligations during the 1-year period before the loan is made times 2.5. Meaning it's basically your average monthly expenses over the past year times, and then it's for each month your average expenses over the past year, and then multiply that by 2.5. So basically they're going to try to give you 2.5 months worth of expenses, or $10 million, whichever one is lesser. It's realistically going to be the 2.5 times.
Before it was actually 4 times. They actually reduced it down to 2.5. So there's constantly being debate on it back and forth until the law rules out. So yeah.
And likely, if you're going to apply for the loan, you would probably have to bring expense statements for the past year so that the bank can see it. So now I'm going to jump into the Economic Injury Disaster Loan Emergency Advance. This is basically a emergency $10,000 grant that's given to businesses that are experiencing temporary difficulties. The only requirement is that you have to be a small business with fewer than 500 employees, which includes sole proprietorships, independent contractors, and self-employed. Private nonprofit organizations, 501c veterans organizations can also apply for them. The application is actually just on the SBA website. They said the form should take you about 2.5 hours to fill out. So you can go on the SBA website and fill out that form and see if you qualify and if you're approved for the emergency $10,000 grant.
There's some ambiguity whether it has to go through a bank or not, but just go on the website right away.
There's also something called an Sba Bridge Loan. It's another mechanism that's designed to help small businesses. Let me jump to the next one. This program was actually created in October 2017 to supplement disaster relief capabilities of the SBA. It was created so that the SBA could provide direct loan assistances to small businesses to support the survival and reopening of small businesses. You can get up to a $25,000 loan. We're not going to go into too much detail about it here, but that is one mechanism that is available to small businesses. So you can just jump to the SBA website to get more additional information. Sba Debt Relief is another mechanism that exists also through the SBA. If you had a pre-existing 7A 504 or micro loan, the SBA will automatically pay the principal, interest, and fees for 6 months. Meaning, if you have an existing loan with the SBA, it'll just be, you just don't have to make any payments for 6 months. If you are now going to have a new loan with the SBA, a new 7A 504 or micro loan, it's also, the payments are also going to be made for up to 6 months as well. So that information is also on the SBA website under Sba Debt Relief. We're not going to, again, go into too much detail about it here because it didn't actually come along with the coronavirus legislation that's been rolled out federally. So this is sort of just businesses that are forced to close, where I just kind of want to talk a little bit about what you can do for your employees, what your employee. So the question is, what benefits can my employees get if I'm forced to shut down the business or lay a lot of employees off? So as a preliminary disclosure, as a general rule, we don't want the employers who are doing layoffs to do it in a discriminatory, retaliatory, or harassing reason. It should be done in a fair and equitable way, because we don't want you to be open to a lawsuit, because if you do it discriminatory, for a discriminatory reason, retaliatory or harassing reason, you could open yourself up to a lawsuit. So there are several types of benefits the employees can get. The employees can get unemployment benefits, which is going to be their normal amount, but the CARES Act added an additional $600 to all unemployment benefit checks, essentially, if they qualify for that specific unemployment benefit under the new CARE Act that's come out. There's also state disability insurance. If the employee essentially has any kind of disability, which could include the coronavirus, the SDI will give the employee 60 to 70% of their wages. But however, this does actually require a doctor's note and a diagnosis. Also, employees who are unemployed or partially unemployed or are unable to work due to COVID on or after January 27th to December 31st, 2020. This is for unemployment benefits, and these benefits will last for at most 39 weeks.
And I apologize, David, is this affected by COVID, meaning physically affected, or the business is affected by COVID?
Both.
Okay.
There's also an individual stimulus package. An individual shall receive as a tax credit equal to $1,200 or $2,400 if jointly filed, plus $500 per qualifying child for the 2020 tax year. Does that mean it's going to be refunded in April of this month in 2020, or does that mean it's going to be sent out in for 2020's tax year, meaning filed in and sent out in 2021? The statute is actually unclear about that, but there's a lot of debate going back and forth as to when that's actually going to be coming out. The above tax credit will actually be reduced by 5%, so much of the taxpayers' adjusted gross income as it exceeds $150,000 for joint filers, $112,500 for heads of households, and $75,000 for everyone else. Meaning, if your income exceeds that amount, then your the stimulus package will be reduced by 5%.
Yeah, I've been seeing some news that the tax credit may actually just be wired directly to you, but we don't really know. So there's just been a lot of news all over the place that it's just going to be directly wired to your bank account. I mean, we don't know. This one, we're just taking a guess. So sorry about that.
This language is coming straight from the statute, so it's unclear as to exactly what that means and how that exactly is going to work as well. It's not actually clear because there haven't been any new rules promulgated to kind of explain that yet.
And it's so crazy because, because of the fact that when we read the statute, then we read, for example, Department of Labor website, and then actually implementation, those three things could actually be totally different. So, there's a lot of risk involved.
So there are eviction moratoriums that were issued by actually cities. There's actually some confusion as to whether or not it's actually come out by state or cities. Paul, next slide.
Yep.
So on the state level, the Governor Newsom enacted Executive Order N-2820, which makes it unlawful to price gouge after a state of emergency has been declared. It's effective March 16th and will last through May 31st, 2020. So that's no price gouging. That includes rents as well. And also in this order, it empowers local governments, which is cities and counties, to impose limitations on evictions for non-payment of rent or foreclosures due to layoffs, decreased income, or because of medical expenses caused by COVID-19. Meaning the eviction moratoriums are going to be specific to cities and counties. It's not actually implemented statewide, but the state did empower local governments to create their own local ordinances to stop evictions.
So if you look online, everywhere it says Governor Newsom moratorium. There is no moratorium. It just was an executive order to empower local cities and counties to enact their own local statutes to be able to prevent eviction based upon their own specified reasons.
So what that means to realtors is that if there's a rent issue and one of your clients is contacting you about a rent issue, you want to check that city's website to see if they have any sort of eviction moratoriums in place. I have a brief list of cities that do have them a little bit later.
And you have to remember, there's going to be a lot of people wanting to sell their properties because renters are not paying. You really should not be telling the buyers, unless you've researched it, that no worries, we can just evict, because if there's a moratorium in place and the person purchases the property and is unable to evict them for, let's say, until the end of the year, you as the agent may be found liable for providing that advice.
The other gray area here as well is that what if the court is located in, for example, Los Angeles, the city of Los Angeles in downtown LA? Will that court even be open? Will that court even evict somebody who's not in there in that city? It's unclear.
You're not going to be. Right now, our recommendation to landlords, you got to work with the tenants, whether there's a moratorium or not. You're not going to be able to evict anybody right now. It's just how it's working.
The other big point about N2820, which is that executive order by Governor Newsom, it requests financial institutions who are holding home and commercial mortgages to implement an immediate moratorium on foreclosures and related evictions when it arises out of a substantial decrease in household income, business income, or substantial out-of-pocket medical expenses, which was caused by COVID-19 or any governmental response to COVID-19. So they're asking essentially banks to stop foreclosures and evictions for people who are missing their home or commercial mortgage payments. It's a request, it's not mandatory, it's a little vague.
We're talking about that. Okay, next. Mm-hmm.
So the County of Los Angeles does have an executive order, which is an eviction moratorium. This is just an example as to how it looks like. This order says no residential or commercial landlord shall evict a tenant in the unincorporated county for non-payment of rent due to COVID-19, and the tenant has provided notice to the landlord within 7 days after rent was due, or other reasons amounting to a no-fault eviction under the county code. I have noticed a lot of the moratoriums actually have a notice requirement. The tenant actually has to send something to the landlord saying, hey, look, I can't make my rent payment because of COVID-19 or some other concern like that. And then also this particular moratorium has states that tenants shall have 6 months following the termination of this order to pay the landlord back any back rent and are encouraged to negotiate a payment plan. A couple of the eviction moratoriums have similar provisions as well. There's also a County of LA rent freeze. So there was an order dated March 30th, 2020 that prevents rents from being increased during the effective period, which is effective from March 31st to May 31st of 2020. So here are some cities that I found that do have eviction moratoriums: San Gabriel, Alhambra, El Monte, Arcadia, Rosemead, and of course this list is not exhaustive. Paul, you want to take this over?
Yeah, just social distancing. I know a lot of you are doing, trying to do caravans, but I just want you to know that it makes showing of homes more difficult because there's social distancing requirements. Is it being enforced? The answer is, I have not had a client come to me, but I've been hearing anecdotally that there are citations being given to people. So I want to make sure that, you know, you're careful about it.
Also come Friday,
okay.
Come Friday, there's a new order that says from the city of LA that's requiring people to wear face coverings when they're outside now. How that's going to be enforced, what that means, it's still, of course, is still in the gray area. And it also does impose requirements on the employer to provide face masks. And I think this is a little bit difficult at this time because face masks are really hard to come by from stores. So if you don't already have them, how are you going to give it to your employees? How are you going to have it when you're outside? It's a little bit of a sticky situation right now.
Yeah, and is the employer essentially going to use the inability to provide face masks as a basis for termination because they can't legally do business? You know, I mean, you know, that you know, these are kind of difficult issues. I actually see Nancy Chan on the right side, so I've just been staring at Nancy for a long time. Hey, Nancy is like a god to most of us. So okay, before we take any questions, you know, I just always wanted to kind of give a brief chat about my feelings. A lot of you know that I'm running for Arcadia City Council, but I really just wanted to kind of articulate the basis for running. So I've shared the story before, but I'll share it again. When I see somebody that's a little bit older, I always help them. And there's a reason why. It has nothing to do with how nice I am. It has everything to do with, I actually believe that there's a God. And so my mom, she's in her 70s. She has a bad back. I have a bad back too, but her back is really bad. And she's fallen before. The reason why I help people that are older is because that I hope that when I'm not around and my mom falls, that somebody will be there for her. So when I do that, and I'm not running for office, you know, the person says, oh my God, you know, if they're Chinese, they typically say, oh, you know, Zhen Luisi, you know, you're such a nice guy. But when I run for office, they actually cry. The same action can produce two very different reactions. And what does that mean? It means that those of you that are in the audience, if you have a good heart and you really have a good belief about something, I really encourage you to run, because it allows essentially people to be impacted in a very positive way. And there are actually issues that if you don't run, don't get talked about. So I'll give you another example. There was a lady I went to, you know, I knocked on her home. She was Caucasian, she was white, and she opened the door. She wasn't very nice. However, she suddenly kind of softened and invited me into her home. And she walked in, you know, I walked in and she began talking to me, and I stayed about 45 minutes at her home, if not longer. I stayed until it was dark. And she shared with me about her family. She shared with me about her kids, many grandchildren, very, very successful. And she told me that she was a teacher. I said, wow, you know, that's great. I spoke to her and her husband. I thought, oh yeah, you guys seem very intelligent. You must be college professors. She says, no, we actually taught young children. And I was like, oh, wow, you know, it's really great. And she basically told me she taught children of color, people like me. And I thought, oh, you know, that's wonderful, teaching people of color. Both her and her husband did it, which was pretty amazing. And she said, oh, I have 2 grandkids over at First Avenue, which is a school in Arcadia. I said, that's wonderful. I said, that's great. And she said, do you know that because they're white, nobody will speak to them? Nobody will talk to them. Nobody will invite them to birthday parties or anything like that. And frankly, I was a little bit shocked, you know, because here I was, you know, I've been in the States now for 43 years. You know, obviously I felt and I experienced things that were inappropriate when I was younger, but I didn't think that happened to other people, particularly Caucasians, you know, people that are white. Well, this conversation that we ended up having, I think, opened up both sides, because here was this person, she had given everything to new immigrants. She was the one that knocked on people's doors. She was the one to welcome them with brownies. And she basically told me in the city of Arcadia, people knock on their doors all the time and tell them, you know, you need to leave because in 10 years, you won't be around. And you meaning Caucasian and white people. So why do I share this story? Because at the end, we were hugging each other. She was asking me, oh, please text me when you get home. She was wonderful. And at the same time, here was this person that I got to meet who had taught people of color like myself for over 45 years. And here she was, I think she's in her 80s, feeling so hurt by giving so much. Well, if you don't run for office, those issues don't get brought up. You talk about it at home, maybe you talk about it with a friend, but it doesn't become a social issue. And so I encourage people to run, because there are many issues that society has that cannot be discussed unless somebody is brave enough to be able to stand up and run. So I really want to just encourage a lot of people to be able to do it. The last thing, very last thing, all right, we're done with time, is the issue about coronavirus and the statement that it's a Chinese virus. You know, I don't know what the president was thinking. And obviously, we know sometimes the president makes statements that a lot of people don't support. He didn't say China virus, he said Chinese virus. So Chinese virus is a big group of people, that includes myself as well. But this is what I want to say, because a lot of people have been talking about xenophobia, is that it's been very rare in your entire life that you are given an opportunity where a source of pain in a country is connected to a specific community group. And I think it's a great opportunity, a wonderful opportunity for Chinese Americans, instead of feeling hurt or merely slighted, that they stand up, that they give back, that they organize together to be able to give back to the community that has given so much to us. So just last week, we were able to help organize, you know, it was a person named Keith Tai, just a wonderful person in the city of Arcadia. He gave the largest equipment delivery. I mean, other people did too, but he did the majority of giving over to Arcadia Methodist Hospital, right? So we were able to organize it, put it all together, and the hospital administration came out. We had given like 13,000 masks and thousands of gloves and, you know, just a whole bunch of stuff. And I don't know who said it, but somebody said, you know, they said, what can we do for you? And the reaction was, well, just don't call it the Chinese virus. And the hospital administrator said, don't get me started. Now, that reaction is actually a positive reaction. What does that mean? You're giving so much, right? You're giving so much. Of course, it's not a Chinese virus, but that reaction can only come, in my opinion, many times when Chinese Americans stand up and give back, right? To be able to give back overtly, not just appreciative in our heart, but appreciative indeed. And so I want to share that with a lot of people because there are a lot of people that are hurt by what the president said, but I consider it an opportunity to be able to be the best American you can be, and that it is our time in our history as a Chinese American to be able to say that America is the best place in the world, and we intend to stand with our neighbors and to be able to say that we love them because in many ways they first loved us, because this country first loved us before we even loved the country. Many of us couldn't come to this country without America opening its doors to us. So with that being said, let us have any questions that may occur. It is 10:18. I think you told me 10:15 was the cutoff. So any questions at all?
One second, Paul. I'm going to bring Sharon back up to the meeting.
Okay.
Okay, there we go.
Hello?
Yes.
Okay, good. So, hi, Paul. We have 3 questions here. So the first one is, as self-employed, if I apply for EDD, then does that disqualify me from forgiveness for SBA loan?
At this time, the statute doesn't say that you're excluded from it if you apply for EDD or if you have EDD. I would say go ahead and make the application and see if the bank will go ahead and provide the loan.
Okay, the second one is my bank is too slow to file the PPP. Do you know a reliable bank to act as our agent?
Go ahead and go on the SBA website, specifically Google for the SBA 7A lender. And then if you Google that and you click the first link, it'll actually direct you to the SBA website, which will, your zip code, you can find another bank.
Yeah, our understanding is that the SBA loans through financial institutions, it's a value add. And because it's a value add, oh, there's a lot of static. Is it?
Yeah, Sharon, something I think scratching your mic. There's a lot of static coming from your side. Okay, there we go.
Okay. We've been told through banks that this is more of a value, that this is more of a value add. Oh, maybe it was me. That this is more of a value add. So banks really don't make that much money through the PPP. So with that being the case, understand that banks may not be as quick and efficient with working with people. This is what we've been hearing. Again, it's anecdotal. So what's the third question?
Here's the last one. So does part-time realtor qualify for unemployment insurance under CARES Act?
It doesn't say that. So long as you are affected by COVID-19 and having reduced hours, you don't have to be fully unemployed to get unemployment benefits. Even partially unemployed because of COVID-19 is sufficient for you to apply and potentially get unemployment. So I would say go ahead and make the application and see if you're able to get unemployment benefits.
So this is different from the CARES Act is a federal statute. It's different from state unemployment. So we will always want to differentiate between state unemployment that requires you to be an employee, independent contractor. That's inaccurate. You're not going to be able to get state unemployment, but for federal CARES Act, you may be able to get it. So we want to caution you that we have seen for state unemployment that retroactively years later, they come back and they seek reimbursement for a misapplication or improper application. And with the interest, it gets pretty heavy. Do we know if that's going to occur federally? I actually see David's face suddenly really big on my screen, so I was kind of scared. I didn't know what happened. Did everybody disconnect?
No, just your video stopped sharing.
Oh, got you. Okay. So, yeah, you realize you're not as attractive on screen as you think you are in your head, but yeah, so that's the way it works. But yeah, I apologize. It's really scratchy, but I'm not sure why. So, we can't hear you anymore. You have to unmute yourself. Well,
Sorry, Sharon, you're on the line.
Okay, awesome. Thank you, Paul. Thank you, David, for give us this presentation at this special time. Just everybody's know, Paul is running, our Western Gilbert board is supporting Paul, who is a candidate for the 2020 Arcadia City Council District 4. For all members who live in Arcadia District 4, please vote for Paul Cheng.
Thanks, everybody. Appreciate it.
Thank you, Paul. Thank you, David.
Okay.
So the session has been is ended now.
Bye. Thanks.